Welcome to Resolutions, the official podcast of the American Bar Association section of dispute resolution. Every episode is a journey into the heart of conflict resolution, guided by our diverse community of experts. We're here to explore innovative strategies, share wisdom from the field, and inspire excellence in resolving disputes. Whether you're a dispute resolution professional, a curious learner, or someone passionate about fostering understanding and peace, you're in the right place. Let's dive into today's conversation and discover how we can transform conflict into opportunity together.
Welcome, everyone. We are delighted to be sharing this podcast with you. We have two guests, Michele Kern-Rappy and Laurie Vahey, and I'll introduce each in turn and then invite them to the stage. Michele Kern-Rappy, she is a national mediator and arbitrator, principal and managing member at Kern-Rappy Dispute Resolution. Her independent practice spans 35 years of experience, and she's handled more than 7,000 mediated civil cases. She works with groups including Resolute Systems and the New York State Supreme Court, and she's actively engaged in publishing articles and leading ADR committees. She has worked with Laurie Vahey, our second guest. She is a principal and managing member of Vahey Law offices based in Rochester. She is a former chair of the NISBA Torts, Insurance and Compensation Law section. She is a noted leader similar to Michele. Laurie was also the past president of the Greater Rochester Association for Women Attorneys, GRAWA, and she also finds time to serve as a spin instructor for a local gym in Rochester in case you happen to be in the area. Go take a class with Laurie. Today, we are discussing R.A.I.S.E and the R.A.I.S.E roadmap. And so with that, let me invite Michele and Laurie to the stage. Michele, Laurie, welcome.
Thank you so much. What a pleasure to speak with you today.
Yeah, thank you very much, Rekha. It's great to be here.
Marvelous. Okay, so we're going to jump right in. And so that first question I want to tee off is, early mediation is something that has become more prevalent in the ADR landscape. And so when is the right time for early mediation? Michele, we'll go to you first, and then we'll go to Laurie.
Okay, thanks so much. So I created the first mediation program that was in-house in New York County, and I was the mediator and settlement coordinator at the courthouse. And what I discovered in my 35 years in Manhattan Supreme Court, serving as a referee and mediator, is that there's a paradigm shift that occurs when a case is referred from litigation to court-annexed mediation. And what I found is that the longer the litigation, the more entrenched the positions, and the more challenging this paradigm shift is for mediation. So the earlier, Rekha, the better. While it's ideal to have everyone at the mediation participating, including insurance companies, what I found is that upon the transfer to a mediation, there's resistance. And the older the case, the more of that resistance. And in thinking about it, there's inherent challenges that mediation presents. A litigator and a mediator, they're tasked with understanding and navigating parties who arrive with conflicting interests, fraught histories, varying psychological dynamics, and differing levels, quite frankly, of commitment to this new process. While it makes sense, sometimes if you are the one deciding that this is the right time to go, many times you're not the one deciding. Maybe it's the other time, or maybe the court has asked you to go. So there's a certain ambivalence that we see when you're first presented with a group in a mediation. Also, there's abstract issues, including power, revenge, that often emerge. And we're all, to a certain extent, have inadequate training as litigators to fully deal with these complexities. So at a certain point in my career, I also have students in my program. I've had over 220 students, and we came up with the expression, that the litigators come with a litigation mindset, which is brilliant for litigation, a strong sense of advocacy, analytical thinking, a competitive spirit, but not so helpful for mediation when we're asking for them to have a broader view of the case. So at a certain point, the attorneys would ask for tips. And I came up with a roadmap for that transition to mediation from litigation called R.A.I.S.E. And the R is, as you would think, resistance. Think about your resistance. And then it goes on, the importance of, before you come to the mediator, the importance of building a rapport now with your adversary, someone who may not have been open, in terms of disclosure, and doing research, thinking about the risk involved in staying with litigation. The A involves active listening and acknowledge. And it's important when you're in the mediation to really take a deep dive into the active listening and acknowledging what others say. I ask everyone to give space and attention, respect, and create a sense of curiosity amongst our groups. I try to avoid personally trying to convince anyone of a particular point, particularly at the beginning. And what I found is that it's important to create space for each litigant to begin to align with the mediator and for them to have a sense of trust before you can even begin to start convincing. There's space for adaptation. Insight is midpoint. Once there's insight gained from a mediation, we then move to the creative part where we optimize strategies, we come up with solutions, evolve the case, and eventually work into ending an agreement. So the last thing I wanted to say about the paradigm shift is that in court annex mediations, they're usually 90 minutes, and it takes at least that 90 minutes just to get through security at a courthouse these days. So that's why a roadmap could be very helpful. Thank you.
Michele, thanks so much for offering that roadmap and giving us a guide on how we can reframe, right, to get into that paradigm shift. Laurie is here not only because she's been in active practice, but she is somebody who has implemented R.A.I.S.E and its roadmap in her personal injury practice. So now, Laurie, to you, when is the right time for early mediation?
Well, thank you, Rekha. I think that mediation has become part of the forefront of any civil litigation practice these days, not only because the courts want to do it, they have mandatory programs now, but you'll find that your clients, including their insurance companies, are really more mindful of the benefits of mediation, including decreased defense costs, recognizing that there have been increased verdicts, like value of cases has increased, at least in our area in New York State, and that resolution early may benefit everyone, not only be to have finality, not have a verdict in excess of the insurance coverage available, but it's possible that the plaintiff, if you're defending the case, it may not get better with time. And if you're the plaintiff in a personal injury case or even in commercial litigation, which I also do, that you're getting finality for your client in a way that decreases costs and allows them to, move forward in their life. Because litigation is not a fun time for people. There's usually something that's gone wrong. So I think mediation early is something that's taken very seriously these days by all sides, the parties and their insurance companies. Thank you.
Sure. And so next, if we look to Michele, this framework, R.A.I.S E, R-A-I-S-E, but implementing R.A.I.S E, right, to a litigator who has a litigation or advocacy mindset, what are practical tips that we can offer, that you can offer to get them there, to be open and ready for mediation and success in mediation?
Thank you, Rekha, and thank you, Laurie, for those insights. It's been such an honor and a pleasure to be speaking with Laurie in the past couple of years that we've known each other. But before I get to the tips, I wanted to discuss what we call the 7 litigator sins. Over the past couple of decades at the courthouse, litigators had asked me to send to them before mediation a list of tips. What I felt was helpful in addition to the tips were things that I would ask them not to do. Things could be as effective and efficient as possible. And what would happen with that, because of the sense of ambivalence or resistance, a major issue would be the concern of vulnerability or weakness if an attorney suggested that in the midst of litigation, say at a PC conference or a status conference, that maybe mediation would be helpful. And they appeared maybe too enthusiastic. A lot of the mandatory mediation programs, thankfully, that we have, and Laurie mentioned, eliminate this real psychological fear factor of appearing weak that an attorney could feel. But yet we still have what I like to talk about are these 7 sins. One is the plaintiff not showing up at a mediation. The second is the plaintiff not disclosing certain information that they were supposed to disclose before the mediation for it to be effective, or coming to a mediation with an excessively large demand. And then sometimes even I had it at a mediation a few weeks ago, increasing the demand in the midst. And what you're seeing when you see that, Rekha, is the fact that a proposal needs to be unemotional, but monetary proposals are a form of communication. And when one is too high or one is too low, the parties unfortunately get anchored in those positions. So I include that as one of the 7 sins because it doesn't help anybody. Third, withholding requested information. Fourth, defendant sending an examiner who's unfamiliar with the facts, or defendant not showing up. This week this is another form of ambivalence. The defense came in on the mediation saying, we're ready to settle, Michele, enough's enough. They had just filed a note of issue. We understand the issues, but then there wasn't sufficient authority. There was a very minimal amount of authority and the adjuster wasn't available. So there was no one on the call to get even more authority, even though it was an acknowledgement that it was needed. Defendants spending the day sometimes, if I get a complex multi-party case, defendants sometimes will spend the day arguing contributions with co-defendants or coverage issues. And in that case, it's better to call me in advance and let me know that you need a co-defendant or a defense only pre-mediation before we get to that mediation, so I could help you figure out percentages. Last, defendant not listening to key issues and important maybe to the plaintiff, giving up too early. The tips are as follows. Ideally, the client would be available at minimum, but it would be great to have them in person on the Zoom or at least at home on the phone. Secondly, both parties should come prepared with effective risk management and be prepared to narrow the gap. Reach out to the mediator if you have any questions or need clarity in terms of logistics for your client. If you have a concern about being put maybe with one defendant, or you think it might be better to speak with me privately, or all those things are really, these nuances are important to figure out beforehand. Also, it's very important to submit a pre-mediation statement to the mediator, and what would need to be in that pre-mediation statement are not a regurgitation of the complaint, but more a broader view of the facts, attaching every document that you believe you would be referring to at the mediation, and that I could help you as a plaintiff get the largest number possible, and as a defendant, how am I going to help you to manage risk? Send me those documents, attach it with your statement of the facts. And second, talk to me about not only economic benefits maybe that the client would have, but some non-economic interests. A lot of times in landlord-tenant issues or employment issues or different kinds of construct relationships where you want a continuing relationship, there are non-economic interests. Sometimes even I've had medical malpractice cases where an apology was helpful. Third, it's important to talk about the weakness if you can. Many times in the first pre-mediation, we don't talk about the weakness in the case or the risks in the case, but I would just encourage candor if you feel comfortable with the mediator, either before or in a phone call or during the mediation, because that's how you're going to get the most efficiency out of the session. Explaining to the mediator any history of settlement conferences, sometimes that's key. If you tell me a year ago we worked with a mediator and we reached an impasse because of this level of insurance or that, a family member got involved or something, those are the kind of things I need to know and would be helpful. Also, give me your settlement range. I want to get a sense, if I can, of the delta between the demand and the offer. And then, of course, give me the important names of every single person who's going to be on the Zoom, and who has authority, especially as I'm sure you'll hear more from Laurie. There are various levels of insurance, and sometimes an important person like an excess carrier is not on when they should be on. And that kind of thing is very helpful for me. And so I'm going to give this now to Laurie.
Thanks so much. That was a great entry. So, Laurie, we're going to you, and I want to dive in just to give a case example almost, right? Insurance industry as the example of how do you prepare for a mediation in a case that involves insurance where there's no discovery? And so, how do you get into that? How do you prepare? What are features of mediation that you're really anticipating and relying on for success, defined broadly? Laurie?
Thank you, Rekha. It's a great question. So some of the things, the tips that we do, so if we're going into a mediation we haven't had discovery yet in the case, we'll approach plaintiff's counsel typically because in order for an insurance company to settle the case, they have to document their file. Plaintiff's attorneys know that, they're well versed in it. They know if you're going to get into litigation, a lot of information is going to be disclosed anyway. So what we've done in certain personal injury actions is we've asked for medical records or authorizations ahead of time. We get an expert early they don't have to do a full-blown independent medical exam, but have them do a record review so that the insurance company can look at their file and understand. And if you're a plaintiff who hasn't had discovery, boy, you're worried about, is there anything on the table insurance-wise that I haven't seen or don't know about? So we really recommend when you do plaintiff's work that you're sending out letters almost immediately upon being engaged to any potential party that you're aware of, and thinking yourself where insurance may exist and writing to those companies to find out how much coverage there is. That could include a homeowner's policy, commercial general liability, an automobile policy, or excess. We had one case resolved. There was a commercial truck and it ran a stop sign. We represented the commercial trucking company and it hit another car. And we knew that liability was going to be absolute. So we mediated early, got authorizations early, had a record review of the x-rays and other medical records because plaintiffs did agree to, disclose that information and provide it to us ahead of time. But they were smart. They asked for, all the insurance information, and they also asked for the excess policies. It's important early on if you think you're going to be into an excess policy to ensure that you get that information, you put them on notice. And if someone discloses that there is no excess policy, when you ultimately do get to the mediation, ask for a no excess insurance affidavit if you go to settle that case, if you're the plaintiff. So if you're the defendant early on or representing someone who is facing early mediation, you're going to want to have those conversations with your client early. And maybe if they don't know you're going to be, hey, who's your insurance broker or agent? I'll call them directly. I'll find out for you. I'll ask, about all the insurances you have and find out if there's anything that's applicable so I can put them on notice and get them engaged early. And I think Michele is absolutely right when she talked about contribution. You could have insurance companies who are fighting over who's going to make the first offer. You don't want to do that at the mediation and waste all the mediator and the other party's side. Then plaintiff's going to get mad if you're the defendant. So if you're defense counsel thinking about this, you're going to want to you don't represent the insurance company unless you're coverage counsel. You're going to want to get engaged in having someone, these insurance claims professionals actively involved, providing them all the documentation so that they can document their file and get some reserves money to offer, and then making them take a position by asking for that in writing, making sure that that's pushed up to the necessary supervisors at any insurance company. And then hopefully, you're off to the races and you're going to have a successful mediation.
It's interesting, this idea of involving experts early to review records. We're seeing that even in the practice, depending on the case and the costs involved in international arbitration, where you bring in the experts to help build your theory of the case, to make sure that you're understanding things in parallel. And so I just think it's something that's coming up a lot more nowadays, right? So we even talk about the introduction of early mediation, right? But also this in parallel. And then you've talked about how for mediation to be meaningful, right? Not only what do the plaintiffs have to bring to the table or be aware of, but then what do insurance companies need to do? And in there, you mentioned, coverage counsel a bit. And so can you get into that for us a little bit? What is coverage counsel? How do they operate?
Yeah, that's a great question, because if you're not familiar with coverage counsel or their role, you can have some ethical issues. So it's good to identify defense counsel's role in any litigation versus coverage counsel. So in a defense counsel role, if there's an insurance company involved, it's called the tripartite relationship. So you have a client and you have an attorney who's defending that client, but that's paid for by the insurance company. And there's often reporting requirements and the like, but the client is really the only, in the tripartite relationship, the only one that the attorney has the obligation to ethically, and shouldn't be disclosing anything to the insurance company or doing anything that benefits to the insurance company to the detriment of their client. So what the insurance companies do oftentimes, or what a defense counsel can ask an insurance company to do, is, hey, insurance company, go get your own attorney. That's coverage counsel. So coverage counsel is going to be hired by, paid by, and advising the insurance company what its obligations are under its policies to avoid liability above policy limits, and advising them sometimes on the value of the case. So it's really important, if there is coverage counsel, that you're updating coverage counsel on what you think is, if you're the plaintiff attorney or the defense attorney, what you think the value of the case is, because they're going to be acting in the best interest of the insurance companies, but understanding the insurance company's duty of good faith and fairness in dealing with its insured, the defendant, in any potential lawsuit. So coverage counsel is someone who is going to have a lot of sway in getting proper authority to make a settlement offer.
This reinforces, thanks so much, Laurie, what Michele was saying about all necessary parties with appropriate authority need to be at the table or able to be contacted. So there is meaningful early mediation. I'm going to stick with you, Laurie, for one more question here and just ask, because you have a vantage point, having worked you're in upstate in Rochester, you come down into the city too, but have you seen differences in the practice of mediation between downstate and upstate?
So, we do have the luxury here that we're in Western New York, but enjoy coming downstate. We have a lot of cases downstate. So there are some differences. And so in upstate New York, you'll find that people really know each other, including the mediators, because it's a smaller market. The mediators, they know the attorneys and those things. And so you can be mindful of that. It sometimes behooves you to maybe get a mediator from out of the area. If you need someone who's totally objective, or there's a concern by one party that, hey, I'm not going to get a fair shake if we have a mediator in, our area of Western New York, you might go downstate. In terms of practice itself, I think The court mediators, they're super talented everywhere, which has been, a really great investment by the court system. But I will say, I think the downstate practice of mediation is similar in approach in the sense of everyone's very professional, upstate, downstate. As Michele pointed out, really understanding it quickly to be able to recite to your mediator the facts and the law involved. It probably doesn't have as much time if you're with a court mediator. I think Michele mentioned 90 minutes. When we're here in Western New York, you're finding anywhere from 2 to 4 hours with a court-appointed mediator for a mediation. So some differences in terms of timing, but I think everybody's really talented. The same process typically applies that we see in terms of pre-mediation statements and requiring people to be in attendance and the like. So I think it's important to just understand the people involved who are going to be the actual ones with authority in making the decisions. Do they need to go outside their location with a mediator? And if not, then you'll find that it's a pretty simple process.
Well, I like also what I've heard that as somebody who runs an arbitration center in New York, I'm constantly going around in the US and the world and explaining how the US, but New York in particular, the whole state, is really professional. And you both have reinforced that hugely. So thanks, Laurie, for pointing that out. We're going to culminate here. Michele, the last question goes to you. And so you shared a lot about, and first getting into some of those sort of sins we talk about. What do you need to be able to come to the table ready for success, defined broadly in all of its hues, right? And a lot of those things, these, I would even call them, and I'm paraphrasing now, client sins, right? Are the right people coming to the table with the right attitude. And that's everyone involved. And so the question is, okay, it's one thing for the client to be there and to sort of gauge from their representation, their counsel litigator entering the mediation world. Okay, what are the cues I should take? How should I be acting, right? So then it's very important that that counsel litigator is emulating good behavior. So everyone involved is coming to the table. And so how does understanding the nervous system, how can get a better understanding of that impact success for the litigator counsel in mediation?
That's a great question, Rekha, and I'll answer it a little personally. In my 30s, as the mediator in the courthouse, many litigators would come to me and say, that, the other side, we're in this this long conflict, and I don't trust that the other side is going to, be as transparent as you're asking them to be. And this is all going to be a waste of time. And I got a lot of that. And I started to feel that sense of frustration, case after case, because I was doing 40 cases a month at the courthouse through my program. And I myself started to want to figure out my own emotions about dealing with the really strong, I was dealing with building collapses, gas explosions, and that was just, on a Monday, any old Monday. So I became a yoga teacher, just not so much to practice and teach yoga, although I did volunteer with cancer patients at our local hospital, but I learned to understand mindfulness and to understand emotions. And this way I could help myself balance myself out when there were miscommunications to try to manage what was going on in my program and also give the tips that were requested. The study of yoga, I'll say, the study of mindfulness has been something I've been studying for the past 30 years. And those traditions have been of great help in understanding the nervous system. But I want to first say that a proposal in a mediation must be unemotional and well thought out in order to get your best numbers. So before you get to that proposal, you need to understand the emotions of settlement. There's a lot of underlying negative emotions, and monetary proposal are a form of communication. And the subject of the communication is the range in which the settlement could take place. So parties in a litigation often miscommunicate through their proposals. People become misunderstood due to those proposals, those actions. And we have to understand that people who know each other often miscommunicate through their words, through their actions. So, of course, in a litigation or transferred into a mediation, there's going to be huge challenges of trust and miscommunication. And so when we recognize that there are challenges, those are the things that you should really convey to your mediator in the pre-mediation statement, Rekha, so I could understand, oh, there's been significant litigation and significant hostility between this and this. And so then I could help you with your proposals, because what even happened just this very week, someone came in because of the hostilities and, maybe the lack of trust. They both said they were ready for the mediation, a multi-million-dollar demand, and the other one responded with about $10,000. So, there was the delta, and it only got a bit worse from there. And I had to talk to both of them because people could feel, say, as an insurance company or a defendant, criticized by a very high demand, and people could tend to take it personally. So that's where I want to get into. I started to learn the autonomic nervous system, which has two basic modes, a sympathetic and the parasympathetic. The sympathetic nervous system is your fight and flight, and it's the gear that we shift into when we're in danger or in a stressful situation. And the parasympathetic mode is also called rest and reset, and that's the mode that we're supposed to downshift back into when we start to relax and don't feel so tense. So the issue, the problem, the challenge for us all in a mediation is that we're bringing some of these fight or flight emotions from the litigation. It only intensifies when we're all facing one another on screen. Before mediation, I have a couple of tips. Take a walk outside, break up your day. If it's a 10 a.m., maybe take 10, 15 minutes and try to relax, try to be in a nice state of mind, not only for you, but because your client is going to be relying on you too, and to acknowledge and recognize, which is part of the R.A.I.S E, that there may be some emotions and want to have a private conversation with the mediator about that. So taking a walk could be helpful. Also, number two, breathing a little bit slower. I prefer the 4-part breath. An inhale, holding for 4 counts, an inhale for 4 counts, holding for 4 counts, an exhale for 4 counts, and then emptying for 4 counts. And I myself do that before a mediation so I could hold the room, hold the space. And last is listening to sounds of nature. I love being outside, and I find very regulating to take a quick walk, listening to the sounds of nature. So thank you very much for the question.
Thank you, ladies, so much. Not only from being powerhouses, in their own practices, but also balancing, whether it's spin or yoga. It's a good reminder on mindfulness. We need to be able to do our jobs well. We need to have frameworks and roadmaps like R.A.I.S E, but we also need some time to decompress. I want to thank Michele and Laurie. It has been a spirited and delightful. Thanks for making time.
Thank you. It's been a pleasure. Thank you both.
Thank you so much.
Thank you for joining us on Resolutions. Today's episode has illuminated the powerful impact of effective dispute resolution and showcased the incredible individuals who dedicate themselves to this important work. Our mission is to explore the diverse world of dispute resolution, and we hope we've inspired you to engage with conflict and collaboration in new ways. If you're not yet a member of the ABA section of dispute resolution, we invite you to join our community of professionals making a difference. Your involvement can help us build a more harmonious society together. And if you found value in our conversations, please consider leaving us a review and a 5-star rating wherever you listen to podcasts. Your feedback helps us reach more people and continue our journey towards excellence in dispute resolution. Until next time, keep solving problems, building bridges, and creating positive changes in your communities.